The ICRC's newly adopted institutional strategy for 2019-2022 holds as its first strategic orientation that we shall influence behavior of the belligerents to prevent violations of IHL and to alleviate human suffering. Among other things, we believe this requires a strong focus on prevention of violations of IHL. Efforts must be made to influence and change the behavior of the parties to the conflict to prevent violations of IHL, as I mentioned, and violations of fundamental rights. But also requires an effort to change laws, policies, and practices when relevant, especially those that may have a harmful impact on people affected by this violence. And we believe that this should be read together with the third strategic orientation of our institutional strategy, which is about working with others to enhance impact. And when it comes to influencing behavior, and in particular influencing towards the implementation of or respect for IHL, international humanitarian law, working with others necessarily includes working with academia. And this is precisely what we are celebrating tonight. The academic world has the capacity to shape debates and to influence decision-making on humanitarian issues of concern. So I'm particularly happy to be introducing this ceremony tonight and to be recognizing the work that has been done by the two laureates of the Paul Reuter Prize tonight. Just to say a few words on the prize itself. The prize is generally awarded every 3 years for major work in the field of IHL. In particular, it has been awarded to scholarly works that aim at enhancing knowledge or understanding of IHL. And the two publications that we are awarding tonight entirely deserve to be recognized for those reasons. Not only do they both tackle very topical issues in the field of IHL, but they also distinguish themselves by having very practical consequences and offering very concrete proposals. And to add to that, I'm also delighted to see the diversity in the works that have been rewarded and are rewarded tonight, because the Paul Reuter Prize has been awarded in the past to works written not only in English, but also in French and in Spanish. And tonight, again, we have two very good publications, one in English and one in French, and I'm personally very happy for this. But first, to say the best words about these two publications, I will soon give the floor to Monsieur Bugnon. And Monsieur Bugnon, if you allow me to introduce your prestigious career, and I think Monsieur François Bugnon is well known to our audience tonight. He's a key figure of the ICRC and a leading name on IHL. François Bugnon joined the ICRC in 1970 and held numerous positions, including as a delegate in Israel and the occupied territories, in Bangladesh, Turkey, and Cyprus, and then as head of mission in Chad, Vietnam, and Cambodia. From 2000 to 2006, you were the Director of International Law and Cooperation here at the ICRC. You were a member of the ICRC Assembly between May 2010 and until 2017, and remain today an honorary member of the Assembly. And of particular importance for tonight, Monsieur François Bugnon was until last year the president of the Paul Reuter Fund, and since then has been replaced by Maya Herty-Grandal, a member of the ICRC Assembly herself. Et je vous salue aussi, Madame, ce soir. In his capacity as president of the Paul Reuter Fund, Monsieur Bugnon oversaw the reviewing panel and the jury looking at all the works that have been submitted for this prize, and hence is the best place to say a few words to the laureates and hence present you with the prize. So, Monsieur Bugnon.
Merci. Good evening to all of you. Thank you, Anne. As Anne just mentioned, I used to be in charge of this fund. The actual president is Professor Maya Herty-Grandal, member of the committee. But since I supervised the process till the decision of the jury, Maya, and I'm grateful for it, suggested that I follow through also for this ceremony. If you allow me, I would like to start with paying a short tribute to Professor Paul Reuter, because if it were not for his initiative, we would not be here this evening. He was an eminent French lawyer, specialist in public international law, professor in universities of Poitiers, Aix-en-Provence, and eventually Paris at the Sorbonne. He was the legal advisor to Jean Monnet and then Minister Robert Schuman in the drafting of the treaty which established the European Coal and Steel Community. So you will tell me this is old history. There is no more coal, no more steel in Europe. It is imported from China. But the treaty was not about coal and steel. It was about the peace of Europe. And the idea was to merge the French iron ore deposits with the German coal deposits in a single economic unity to make war not only an old-fashioned concept in Western Europe, but materially impossible. So I think that with this treaty, they really laid the basis of the peace in Western Europe, of which we benefited for the last 60 years. He was also an eminent member of the International Law Commission and the rapporteur on the draft convention on the law of treaties. So he played a major role in the drafting of what is today the Vienna Convention on the law of treaties. And as humanitarian workers, we are all indebted to him for a specific provision, which is Article 60, para 5, which says that the provisions on suspension or denunciation of a treaty due to lack of compliance by another party do not apply to treaties of a humanitarian nature, and specifically to the provisions on the prohibition of reprisals in such treaties. And with this, he really protected the Geneva Conventions and other treaties of humanitarian nature from the mechanism of denunciation or suspension due to lack of compliance by another party. In 1983, Professor Reuter very generously made a big donation of money to the ICRC to set up a fund to reward outstanding works in the field of international humanitarian law, so that with this fund, or the revenue of this fund, it would be possible to award a prize for outstanding works in the field of international humanitarian law, and thereby stimulate interest and studies in this field. I think this is the 11th time the prize is awarded. The jury is made up of independent experts, and as former president of the fund, I would like to express deep gratitude to Professor Robert Kolb and Professor Theodore Christakis, who accepted to serve, and it's a heavy work, in the jury of the prize. We receive, as response to the appeal made 4 years ago, a huge number of projects or published books, so many that I suggested to the secretary in charge to reserve a big room just to have them, all of them on the table, and we asked somebody, with a chariot to put them, because otherwise we would have spent half a day just transporting them. And then the legal division made a first choice, the legal division of the ICRC, but the final choice is not made by the ICRC, it's made by the jury, so as to have an independent and academic founded decision and no suspicion of any interference in academic criteria, that academic criteria would be applied. I must confess that, and I think Professor Korb, if you allow me, I must confess that the jury at the end felt extremely embarrassed because after making one selection and another, we ended up with two outstanding papers or books, really two outstanding documents. And eventually, even though we consider is it lack of decision to shrink from such a decision, we believe that justice, or rather equity, should prevail, and that it would be unfair that one would be left on the side just because it happened that year we had two outstanding projects. So congratulations. That's why today we have two laureates. Ladies first, I would salute Dr. Julia Grignon, who is now Associate Professor and the Director for Graduate Studies at the Faculty of Law at the University of Laval in Quebec. She is also co-director of the Clinic of International Criminal and Humanitarian Law, as well as co-founder member of the Interdisciplinary Center for Research on Africa and the Middle East. She's interested in all aspects of international law, but in particular, international humanitarian law. She edited the book Tribute to Jean Pictet. Jean Pictet used to be, for one generation, really le maître à penser on all legal and statutory matters at the ICRC, and all ICRC staff members of my generation are deeply indebted to him. She has been also a committee member for several years of the Jean Pictet competition, which is a moot court, and she's currently working on conducting an individual research about the extraterritorial application of international human rights law in the context of external military operation. Now listen, extraterritorial application of international humanitarian law, whereas her PhD, the book for which she is rewarded, is l'applicabilité temporelle du droit international humanitaire, so temporal applicability of international humanitarian law. So I believe this is really a strong example of implementing the two main categories of the human brain according to Professor Immanuel Kant, namely space and time. So congratulations for this outstanding publication on a subject of high importance, particularly in the last and the present century, with those protracted situations of conflicts or situations of occupation where it is so important to determine the beginning and end of implementation. Dr. Lawrence Hill-Cawthorne is today Associate Professor of Public International Law at the University of Reading in Great Britain. Prior to joining Reading University, he was graduate teaching assistant in public international law at the University of Oxford, lecturer and director of studies in law at Merton College, Oxford. So after that, the rest is not so important. People who really reach such position in such high center of learning as Oxford Merton College, it's really incredible. He was also a fellow of the John W. Klug Center, Library of Congress, Washington, treasurer and member of the executive committee of the Oxford Pro Bono Publico, which is an organization of students and academics giving legal support to voluntary organizations. He has been also acting as advisor to United Nations Special Rapporteurs, the International Bar Association, and the European Parliament, and other cases. His work, Detention in Non-International Armed Conflict, published in Oxford, also a very important subject, since, in my view, the guarantees offered or not offered to combatants in terms of conditions of detention and legal protection in case of capture are, in my view, the key to implementation or lack of implementation of humanitarian law in situations of non-international armed conflict. So I believe the two laureates deserve tribute for having dealt with highly delicate subjects also of a great actuality. Now I think it is time to hand over the certificate due to them. Voilà. Félicitations et bravo.
Merci.
Bravo et merci à vos félicitations. And félicitations, congratulations. Voilà. It is now for each of the laureates in maybe 5 minutes to say a few words about their studies. I leave them there. Here. So we leave Julia. Yeah. Yeah.
Thank you. I'm truly honored to receive this award tonight. Actually, there could not be another prize that would make me as proud as I am tonight to receive this one. And since I received it for a work that I did in French, please pardon me if I continue in French for this part of this evening, then I will go back to English for the panel discussion. Si je suis si honorée de recevoir ce prix ce soir, c'est pour plusieurs raisons, et je suis très émue à ce moment. La première, c'est que si j'ai commencé une thèse de doctorat en droit international humanitaire, c'est parce qu'au moment où je la commençais, je réalisais que je ne pouvais pas partir sur le terrain pour des raisons personnelles. Et pour autant, je voulais quand même apporter une contribution à une institution, le Comité international de la Croix-Rouge, en laquelle je crois fermement, dont je partage les valeurs, des valeurs qu'aujourd'hui j'essaye de véhiculer dans mon travail, et dont je partage aussi les modalités d'action. Et donc recevoir ce prix Reuter aujourd'hui, alors évidemment j'intègre pas le CICR aujourd'hui, mais recevoir ce prix aujourd'hui ici représente beaucoup pour moi. La deuxième raison pour laquelle je suis si honorée, c'est parce que j'ai toujours voulu ancrer mes recherches dans l'opérationnel. J'ai jamais voulu que ce que j'écrivais reste en quelque sorte dans l'éther. Au contraire, j'ai toujours voulu que, d'une manière ou d'une autre, ce que j'ai écrit puisse servir à alléger les souffrances des personnes qui sont affectées par les conflits armés. Et pour moi, ce prix Paul Reuter, hébergé par le Comité international de la Croix-Rouge, représente cela, c'est cet ancrage dans le réel. Et donc que des conseillers juridiques du Comité international de la Croix-Rouge aient lu mon travail et les jugé utile, pour moi, c'est la satisfaction ultime. Une autre raison qui me rend très honorée de recevoir ce prix, c'est de le recevoir de vous, Monsieur Bugnon. Certaines personnes, et là c'est peut-être un peu mon côté midinette qui va parler, mais certaines personnes peuvent se réjouir d'avoir croisé une personnalité célèbre au bain des Paquis. Pour moi, je m'extasiais le soir en rentrant à la maison, après une journée passée à travailler à la bibliothèque du CICR, lorsque j'avais aperçu François Bugnon avant une réunion de l'Assemblée qui était venu préparer quelque chose sur un point spécifique, ou encore de croiser Yves Sandeau, avec lequel j'échangeais quelques mots à propos des travaux préparatoires de la conférence diplomatique de 1974-1977 qui a conduit à l'adoption des protocoles additionnels. Mes idoles à moi, c'est Henri Dunant, Jean Pictet, François Bugnon, Yves Sandeau, Marco Sassoli, c'est-à-dire des personnes qui, par leur recherche militante, j'en suis convaincue, font avancer le droit international humanitaire et par là contribuent à humaniser la guerre. Et donc, pour terminer, j'aimerais adresser quelques remerciements. Pour des remerciements exhaustifs, vous pouvez reporter aux premières pages de mon livre dans lequel je donne pas mal de remerciements. Mais il y a ici 4 personnes que j'aimerais remercier. La première d'entre elles, c'est Jean-François Keguiner, qui aujourd'hui est chef adjoint de délégation au Nigeria. Jean-François m'a mis sur la voie du sujet, l'applicabilité temporelle du droit international humanitaire dans des temps anciens. Lorsque je me posais la question de savoir sur quel sujet j'allais travailler, il m'a conseillé de creuser cette question et donc je suis redevable de ce prix ce soir. La deuxième personne que je veux remercier évidemment, c'est Marco Sassoli, qui m'a fait l'honneur d'accepter de diriger mes recherches et qui ensuite m'a fait confiance tout au long du processus, un processus sinueux. Et je remercie beaucoup le professeur Sassoli pour m'avoir offert de très belles opportunités et de continuer de me soutenir dans mon travail. La troisième personne que je veux remercier, c'est Édouard Delaplace, un habitué de ces lieux, qui m'a soutenu du premier jour de mon inscription en thèse de doctorat jusqu'au jour de ma soutenance et qui continue de me soutenir aujourd'hui dans tous mes projets et je lui suis redevable de ce prix. Enfin, les dernières personnes que j'aimerais remercier sont toutes les personnes qui sont membres de la commission Reuter et toutes les personnes qui font partie du jury externe qui ont eu la gentillesse de lire mon travail et de le juger utile et donc de le récompenser ce soir. Merci beaucoup.
Well, thank you very much. I'd like to begin just by thanking the kind introduction from Monsieur Bugnon. I'm extremely grateful, and I'm extremely grateful to be able to come here today and accept this great honor. The book for which I've been awarded the prize began its life as a doctoral thesis again, and so I have a large number of people to thank in the process that led from what I imagine is an extremely poor original application to study a doctoral thesis and the final book, which I hope is an improvement on that. I was lucky during my PhD, which I studied in the University of Oxford, to be supervised by Professor Dapo Akande, so my principal thanks must lie with him. He first introduced me to the topic of detention in non-international armed conflict and guided me throughout the process of researching and reading, no doubt, rather lengthy and poorly constructed early drafts of chapters and gave me great feedback on that. So I'm very grateful to Dapo for that. I'm also very grateful for the research community within Oxford, particularly within public international law, which encourages you to adopt a very particular approach to engaging in research in that field. Essentially, the approach is to recognize that your very specific research question falls within this much broader field of public international law. And that had quite a profound impact on the way my thesis developed over time, and in particular on the final book that was produced. In particular, what I try to do in the book is discuss this controversial topic of the degree to which international law regulates detention in non-international armed conflict by looking at a number of other areas of international law in which similar debates, similar questions have arisen. And that was really from the benefit of studying in Oxford in the public international research community and having Dapo Akande as a mentor and supervisor. Finally, for the book in particular, I have to thank Oxford University Press, who again were just as patient with me as Dapo was throughout the PhD, particularly in my very liberal approach to sticking to time limits and word limits, which was perhaps an even more liberal approach. And at no point was this presented as a problem. I had a great support team. That the international law commissioning editors in OUP were superb, and they supported me a great deal. So without any of this, there's certainly no way in which the book would have been published, and certainly it wouldn't have received this great honor. So in that sense, it's very much a kind of group project, though of course it's luckily just my name on the front of the book. The process of studying this topic, of researching it for the PhD, was a tricky one, largely because detention in non-international armed conflict is, I suspect, a sort of title or subtitle that everyone in this room will have come across in different forms, whether it's a journal article or a book chapter or a conference. It's a topical subject. It was a topical subject when Dapo first recommended it to me, though of course at that point I had no idea that it was such a topical subject. But it's become even more of a topical subject. And whilst writing the PhD thesis, whilst completing the book, I faced this issue that developments were happening all the time in the field. And on the one hand, this is a great thing for a researcher because it produces a great amount of food for thought. But on the other hand, it's a great challenge to be able to keep up to date with these developments. So in this field in particular, we had initiatives of states, like the Copenhagen process on the handling of detainees. We had the ICRC's process on protection of persons deprived of their liberty. We had cases in domestic courts in the UK, in the US, in the Netherlands, in Germany. We had cases in international courts, in Strasbourg, for example. All of these areas where there was a lot going on that I had to try and incorporate. And again, it was very much largely down to Dapo that I did incorporate these things and wasn't sort of left entirely unaware of that. My final personal thanks should, of course, go to my wife, who endured far more than any of the people I've just listed, both during the process of writing the PhD and during the process of turning that into a monograph, which, despite my best efforts, turned into a sort of a further year of work, as opposed to what I assured her would be a sort of 1 or 2 months at most. And of course, I should end by thanking in particular the Paul Reuter Fund Committee and Professor Paul Reuter himself. It's really a true great honor to be given this prize. And it's a great honor not only in international humanitarian law, for which he was so well known, particularly in his promotion of IHL, but also within public international law more generally. As Monsieur Grignon emphasized, he played a key role in some of the significant developments in the broader field of public international law. And so it's a sort of doubly wonderful prize to be given and a great honor. So thank you very much.
We will now move to the second part of the evening, which is the discussion on the role of academia in contributing to the development and promotion of international humanitarian law. So for this, we have the two laureates and François Bugnon joining us. But allow me as well to welcome Professor Robert Kolb, who will join us for this discussion. You already know our three other panelists, so I will say a few words of introduction for Professor Kolb before we start engaging in the discussion. So Professor Kolb is already quite well known as well, I think, from most of you in the audience. So I will only briefly introduce some of the key points from his impressive biography. So as you know, Professor Kolb is Professor of Public International Law at the University of Geneva. He holds a PhD in international law from the Graduate Institute of International and Development Studies in Geneva.
It was international studies at that time.
At the time, sorry, you will tell them to change the website then. I copied-pasted it. You are also a lecturer in public international law at the Graduate Institute, which at the time was called the HEI, and later an associate professor at the University of Bern, an adjunct professor at the University of Neuchâtel. You also taught at the Geneva Academy of International Humanitarian Law and Human Rights, and its predecessor institute, the QD, and as well as the Catholic University of Milan. But in addition to your academic career, you are also a practitioner in the field of international law, which is very useful for the discussion we're going to have tonight. For instance, you worked as a legal advisor for the International Committee of the Red Cross from 1998 to 1999, sporadically for the Swiss Federal Department of Foreign Affairs. And you have been a lawyer with the law firm Lalive and Associés in Geneva. And in 2011, you acted as a counsel for the German government in the jurisdictional immunities case of Germany versus Italy at the International Court of Justice. Very topical for tonight, Professor Kolb had agreed to be one of the external reviewers for the selection panel in the jury for the Paul Reuter Prize. So, and in that capacity, you will also be able to say a few words on the merits of the two books we are rewarding tonight. So on this, allow me to start the discussion. The first question that I would like to ask our panelists, and in particular our two laureates, is on how your research has an impact on the development and promotion of IHL. Maybe, Lawrence, I will give you the floor first, but as you mentioned, your book deals with the question of detention during non-international armed conflicts. It gives a comprehensive overview of the rules applicable in such situations from both the perspective of IHL and that of international human rights law. And you cover a wide range of issues, including on the standards of internment for the different categories of persons that we meet in the battlefield, and on the needs in international armed conflict, for instance, to review the reasons for the internment of civilians, or another example is your treatment of the question on the obligation to release detainees. You also deal with some questions that are very specific to non-international armed conflict, of course, such as the existence of procedural guarantees under customary IHL. So all of this leads me to ask you that question on how you think that your question and the research topic that you chose has an impact today on the development of IHL. And in relation to that, I will also add the related question of how your work has an impact on the practice of belligerence today during armed conflict, so the practice on the ground. Mm-hmm. Thank you.
Sure, yeah, well, it's an interesting question because when setting out to write, well, certainly when setting out to research the thesis and then write the book, it wasn't immediately apparent that this was an area where a book or someone's research could have a clear impact. But over time, as I said earlier, this is an area that has actually experienced a great deal of growth in practice. More and more people have got involved in developments in this area. So there was then scope, which is a nice thing for an academic, to be able to work in a way that tries to encourage a particular development in the law. So in the end, the book did turn out to have, as a key purpose, a contribution to the development of IHL here. Or I should say to the development of international law more generally in this particular area. Because with detention, we're not just sort of talking about IHL as such. I'll sort of start with the end, so to speak. So the book finishes, the final chapter is focused on proposals for developing the law. And that chapter is very much aimed, well, first of all, that chapter acknowledges significant gaps in the existing legal regime regulating detention in non-international armed conflict. And it then goes on to make certain recommendations about how the law might be developed here. The difficulty, of course, is that in this area and in any number of areas of international law, the possibility of a sort of state-initiated development of international law, which traditionally would involve a kind of diplomatic conference and states negotiating a treaty, is certainly not going to be happening anytime soon in this area or in many other areas. So that chapter actually is aimed at those who are presently applying these rules. So it has in mind civil society organizations, it has in mind NGOs, it also has in mind courts and judges, both at the domestic and international levels. And what it proposes are certain interpretations of the existing law and certain ways in which you can rationalize all of the complex, varied rules that exist here in a way that comes up with a regime that's both protective of individual detainees but also workable for detaining authorities. So I said that it's not really just about IHL. We, of course, have IHL and human rights law. We also have international criminal law as a kind of device that has interpreted both of these areas. So that final chapter tries to demonstrate how each of these areas can kind of be used and used together in a way that helps to sort of move the law forward in that sense. The earlier chapters then also seek to give some flesh to the bones of very brief treaty provisions. So you mentioned that I talk about standard of internment, procedural rights for internees, and that's both in international and non-international armed conflicts. So in those chapters, I try to draw on both state practice and judgments of domestic and international courts to give some flesh to those very limited treaty provisions. So again, the hope is that by clarifying how to interpret these different provisions, we can then, present a sort of useful tool, for example, for courts when litigating cases, or for practitioners, such as the ICRC or NGOs, when they're applying the law in practice. So that was the sort of idea. As I said, I was both lucky and slightly challenged by the fact that there were lots of developments in this area happening at the time. It was a challenge, but in the end it's been very much to my advantage because I've been able to sort of be involved in a number of these developments, which has been extremely useful for me and also useful for the book because I was involved in them whilst I was writing the book, and so that could feed into the final monograph. So that's a sort of interesting side point about the value for academics of interactions between academics and practitioners. So the outcome in a number of those interactions, those engagements, was that I was effectively able to work in this area in practice. And already it's been quite successful in sort of drawing some references in practice. So the UK courts over the last several years, anyone that knows anything about detention in armed conflict will be aware of these cases. Effectively, these are cases challenging UK detention operations in Afghanistan, where, among other things, there were questions about the legal basis for those detention operations, the procedural guarantees afforded to detainees. And luckily, I was involved in those cases, and the courts sort of cited both my book and as well as work that I've done with Dapo Akande. And so already, hopefully, we can sort of see some impact there. And that was, as I said, very much intended, at least at the kind of book stage, where I recognized at that point that there was a lot of scope to get involved in practice.
Well, thank you very much. Julien? As was mentioned, your book deals with the temporal scope of applicability of IHL. It determines when an armed conflict exists, first for international armed conflicts, then for non-international armed conflicts. You discussed the beginning of application of the law of occupation as part of that, which, as many of the students in the room know very well, has led to many debates and has been answered by several different theories. You also discussed the end of both types of armed conflicts, insisting, for instance, on the progressiveness of the application of the rules of NIAC, but also on the termination of the law applicable to NIAC. And those, I think everyone will agree that those are also crucial questions today and directly relate to the legal framework that is applicable and has to be applied on the ground. So I will ask you the same questions as I just asked to Lawrence. What do you think is the impact that your research can have on the development of IHL, but also the impact it has on the ground, the impact it can have on the behavior of belligerents?
Thank you. To answer this question, how was my research impacted IHL development? My first thought was close to zero, because it has been written in French, so it's rather anonymous. But then, before going on the substance, maybe a few words about how our research can impact the development and interpretation of IHL. Regarding what I've written in my book, I've been really happy to notice that in the challenges report of 2015, not only the question of the beginning of applicability of IHL, but also of the end of applicability was a question which was hot topics in IHL. But also I was really happy to notice that the conclusions in the challenges report were very similar to those I reached in my PhD thesis. Similarly, in the updated commentary of Common Article 2 of the Geneva Conventions, I was also happy to notice that some of my conclusions were the same as what we can find in the commentary of Common Article 2. So I don't know if I am at the origin of this interpretation and this development of the law, but that was for me, a kind of impact and the debate or discussion about these topics, and that was important to me. Then today, the impact of my research, I can look at it through conferences that I give. And the last example is for the Bruges colloquium that took place last week, and where I was invited to speak about the classification of NIACs, something that I have dealt with in my PhD thesis. And next week, in my teachings, because I will give a 12-hour seminar about the classification of conflict in Aix-en-Provence. So this is two other ways to promote my research. On the substance now, as you said, in my thesis, I look at the temporal scope of applicability of IHL as a whole. And I think that this is the main achievement of this book, because there is a lot of articles or other papers about, for example, the beginning of occupation, but only the beginning of occupation, or about the end of NIACs, but only about the end of NIACs. And I think that to have this big view of all the applicability of IHL was useful to reach some conclusions. And one of them, I choose one of them for tonight, is the end of NIACs. And sorry for those who were in Bruges last week, because I will repeat things that I said last week. Because for the end of NIAC, there remain a lot of controversies about when does it end. And because in order to trigger the application of IHL, we need to have a certain level of intensity and a certain level of organization, one should think that in order to determine that a non-international armed conflict has ended, we need to see that the threshold decrease. Like the level of intensity is not that high, and then that the organization of the non-state party for a time is not as well organized as it was during the conflict. But on the contrary, the Tadic jurisprudence said that the end of a non-international armed conflict is when a peace settlement is achieved. So I discuss this in my book. I think that Tadic is right. We need to have one moment, because if we look at the threshold for the end of application of NIACs, then there is a kind of oscillation in the application of IHL. Because when we have intensity and organization, we apply IHL, but then if intensity decreases, we don't apply IHL. But then if organization is higher, we apply IHL, and then we don't. So I think that's too much uncertainty, and we need to find a moment. But Tadic doesn't say what is the achievement of a peaceful situation in non-international armed conflict. And because I looked at the applicability of IHL as a whole, I decided to apply a concept, the general clause of military operation, that was set for international armed conflicts to non-international armed conflicts. And just to conclude on that question, what I found is that this expression, general clause of military operation, is based on the facts, so it's very useful. And I think that there are 4 elements. The first one is that this expression, general clause of military operation, seeks to extend the applicability of IHL as long as possible. So this is the first indicator. The second one is that the word general is pivotal in the expression. That means that we need to be able to see the end of hostilities on all the fronts, and not only between some parties to the conflict, but between all the parties to the conflict. Then the general clause of military operation, as you said, can only be assessed progressively and in an ex post manner. So we need to wait for a certain time before being able to say that NIAC has ended. And also, the general clause of military operation has to be understood in opposition to the end of active hostilities. I won't enter into deep details about the end of active hostilities, but actually, the end of active hostilities does not put an end to something in IHL, but on the contrary, trigger the application of some provisions, like the release of POWs. So I looked at these 2 notions, and I decided that the general clause of military operation is the expression that we should keep. And in order to conclude, I just would like to say that this is not promotion of my work, but wishful promotion. I now need to write something in English to in an international review, for example, in order to make my conclusions available for a wider audience.
Thank you. So now I'm turning to you, Professor Kolb. As you were one of the external reviewers in the jury for the selection of the laureates, can you tell us what you saw, what merits you saw in the 2 publications we are discussing tonight that convinced you that they were worthy of this prize, and also, generally speaking, that they were important contributions to the development and promotion of IHL?
Thank you. Now I will mix the languages, but I'll start with English, regrettably, because apparently the standard has been set. But I will speak some French later, because we have absolutely to sustain the minoritarian languages. Now, very shortly, I think on the content, on the merits, much has been already said. I guess that you see the main differences between the books here. You have one French-speaking expression, you have one English-speaking expression, and that is not only a question of language, but it's also a question of legal culture. You find in this work, as a quality, an almost perfect example of the best continental style of a thesis, which means that you have a very structured work and to have a very meticulous and precise legal analysis, which goes also into some depth and is not afraid to go into some length. And I don't see that necessarily as a negative point, because on temporal applicability, you had many things to clarify and many uncertainties. The qualities of this book are therefore mainly the in-depth analysis and the originality of thought sometimes, because you had to palliate some uncertainties in the law. Here you have a perfect example of English-speaking style. You have a much more broad approach, less structured chapters, typically the best Oxford style, if you want, but much legal discussion and very dense legal discussion, less subdivisions, very subtle legal discussion, in a subject matter which also was very difficult and topical, many analogies in this subject matter, which were made in a strong way. The title is not completely doing justice to the work, indeed, because you drew on many other subject matters, and in particular also you did not neglect the law of international armed conflicts, from where you draw analogies precisely. The work is, as I said, shorter, and the discussion is plus souple d'une certaine manière. I don't know how to say that in English. But the qualities together is that you have very contrasting works, both, I think, on highest level of their own category, legal style and legal culture.
Thank you. This is not uncommon for academia to be contributing to the promotion or development of IHL, and I think in history, we also have a lot of good examples of how academia and academic research in general can influence international law and IHL in particular. Monsieur Bugnon, I know that you have mentioned to us before a few examples before we started this panel. Would you elaborate on and give us a couple of examples on academic initiatives or research projects in the past that you think were also excellent contributions to the development of IHL?
Thank you very much. As everybody in this room knows, academic work as such is not a source of public international law, therefore not a source of international humanitarian law. But if we refer to the last paragraph of Article 38 of the Statute of the International Court of Justice, can serve as subsidiary means of determination of a rule of law. For instance, if there is a wide consensus within academic circles that such and such rule is customary, then, of course, it could be used as evidence that this rule is customary, or on the scope of application of this rule, or if there is a consensus on the interpretation of a certain provision, again, it can be used as a means of determination. This being said, academic works may combine with other sources and in this sense contribute to the development of international humanitarian law. I will mention two, you excuse me, very old instances. Number one is the so-called Oxford Manual on Laws and Customs of War on Land, essentially written by Gustave Moignet, not in his capacity as president of the International Committee of the Red Cross, but as member, and in my opinion, as the main founder of the Institute of International Humanitarian Law, examined by the Institute at its session of Oxford and adopted, which provided, and this manual, first of all, was used by armed forces to draw up their own internal manual for the conduct of hostilities, for the conduct of their troops, and it was also used as a reference by the International Peace Conferences of The Hague in 1899 and 1907, which used some of the formulations of the Oxford Manual. So some of the formulations of the Oxford Manual, and indeed the spirit, of course, found its way through practice in military manuals and conventional development through the Hague Convention 4 of 1907. The second case is totally forgotten. I refer to a PhD written by a French cavalry officer. The name is Armand Dupeyrat, published in 1910. So we are celebrating the 100th anniversary of the First World War. It refers to this period. Le prisonnier de guerre dans la guerre continentale. So prisoners of war in land warfare. A fairly comprehensive book on the status of prisoners of war, about 400 pages, as I mentioned, published in 1910. And in this book, you will find a fairly detailed chapter, about 20 pages, on voluntary assistance, relief to prisoners of war, and identifying what could, in a future European war, be the role of the Red Cross and national societies and ICRC in providing relief to prisoners of war, which means clarifying actually the content of Article 15 of the Hague Regulations, which provided for the activity of association for societies for the relief of prisoners of war, which did not exist at the time and do not exist today, by the way. And Armand Dupeyrat built all his reasoning on the initiatives taken by the ICRC 50 years before, at the time of the 1870-1871 Franco-Prussian War, under the symbol of the Green Cross, initiatives which the ICRC itself had totally forgotten. And then, strangely enough, the French Red Cross picked up this chapter in the book of Armand Dupeyrat, put it in a report which the French Red Cross submitted to the 9th International, word for word, coupé-collé, on dirait today with a computer. How do you say in English? Cut and paste, cut and paste. Yes, the whole chapter, word for word, submitted as report by the French Red Cross to the 9th International Conference of the Red Cross, which met in Washington in April 1912, which adopted Resolution 6 on relief to prisoners of war, which was the basis of the work of the ICRC and national societies throughout the First World War, leading to the 1929 POW Convention. So I mentioned this thinking to the unfortunate students who work for years on a PhD thesis of which they don't see the end, that sometimes you may expect some unexpected results to stem out of it. Thank you for your patience. There could be, of course, more modern instances. The study on customary law conducted by the ICRC with the help of 100 experts is, of course, one entry for academics, or the revision of the commentaries. But this we could maybe deal later on. Thank you for your patience.
Well, thank you very much. I think it's very useful for everyone to keep in mind the role of academia and academic research throughout history, and the fact that this is not something new and this is not a discussion that is uncommon to have, that academia does have an impact on the development of international law. Now, to come back to contemporary times, I think that when speaking about examples of academic research or initiatives that aim at influencing practice, I think, Julia, you also have a few current projects that are worth mentioning, including your work as a co-founder and director of the IHL clinic in Laval University, and as well as your contribution to the Jean Pictet contribution.
Yes, I'm not the co-founder of the clinic, I'm only the co-director. Fanny Lafontaine is the founder of the clinic, and I'm really happy to join her in her work now at Laval University. Yes, clinical work is a bit trendy these days, and it makes a contribution to IHL, to ICL, International Criminal Law, or to refugee law or human rights law. How does it work? The principle is that students register in a course like any other, and they get 3 credits for that, but they don't work on something like abstract, but on real cases. So we pair them with professional partners of the clinic, and the partners give them a mandate to accomplish. And the students have 1 semester, 1 term to do the research, and they give 150 hours to the partner to do the research. The research can be about a lot of topics. It depends on the needs of the partners of the clinic. That influences a lot the way practically IHL or ICL is applied today, and I choose 2 examples to exemplify this. The first one is the case of one student who was working for the Special Tribunal for Lebanon at Laval University. She was working for the presidency, and she had to do some procedural research about a lot of things that I've forgotten now. And after her implication at the clinic, she got an internship at the STL, and maybe she got it because she did the clinic, because for an employer to have a student that did the clinic is something that is an asset because they behave professionally. So then she was in The Hague at the STL, and she saw that the case for which she worked at the clinic came to hearings. So she decided to sit in the room and to listen to the judgment. And she wrote to us to explain that she was sitting in the room and she was listening to what she wrote during her implication at the clinic. So you see, like the work was so excellent that the presidency decided to cut and paste it and to use it in the judgment. Another example is the Hissène Habré case before the special chambers of the Senegalese tribunals. At that time, we were working with Reed Brody, the dictator hunter, who worked for Human Rights Watch. And that was the first time that a former African dictator was judged before, in front of an African court and while he was alive. So there was a lot of procedural, again, questions that came at that time. And I do remember very well Friday evening a question coming from Reed Brody saying, we absolutely need this answer for Monday morning. I need to give the answer to the prosecutor because it depends on a lot of things for the trial. And then the students worked during the whole weekend. I did also because the clinical work needs a professor to be involved because we supervise all the work done by the students before giving it to the professional. And then they work hard during the weekend. They gave their memorandum on the Monday morning. And again, Reed Brody said, thank you very much, that was excellent. I cut it and passed it into my memo and I give it to the prosecutor. So that was a contribution to ICL and to the Senegalese court. Now on the Pictet competition, who did the Pictet competition in the room? Okay, who apply for next year edition? The students are not in the room. Anyway, I think that a lot of people know already about the Pictet competition. That is a new way of learning, and in this case, IHL, because students are invited to play roles during a week, roles of actors of armed conflict. So, for example, they can be an ICRC delegate in the morning, but the Ministry of Defense in the afternoon, and they have to behave like they were in a situation of armed conflict, but also to answer very technical legal question. And also the jury members who are involved in the competition come from the practice, and they also play a role. So they exchange on legal issues like we were in an armed conflict. The Pictet competition now is at its 31st edition. Next one will be in France in March, and applications are welcome until November 8th. I think that today, to put in a CV that you have done the Pictet competition is a real asset in the IHL domain, and that proves that you know IHL very well. So I think that's a good way of promoting IHL.
Thank you. So you mentioned a couple of things, and you mentioned the impact that students had on courts, actually, and Lawrence, in your previous comments, you also mentioned what you researched on case law, and I believe you're also working at the moment on a project on the use of international courts in state disputes. Would you want to say a few words about your current research and the impact it has in practice?
Sure. At the moment, I'm doing a few things. Two current research projects. One of them is looking at the way in which different international courts and tribunals are being used in the Ukraine-Russia dispute. By dispute, I'm referring particularly to Crimea and activities in eastern Ukraine, and the huge number of different international tribunals that have been engaged in that particular litigation. I'm also working on a project on relating to a UK case going through the courts at the moment concerning arms exports to Saudi Arabia. So two entirely uncontroversial subjects, following on from my uncontroversial PhD thesis as well, I guess. Now, each of these projects is sort of looking at how international law is being used in practice, and in particular, the ability for different courts and tribunals to both apply international law, but also to affect some kind of solution to a particular international problem. So, of course, with Ukraine-Russia, the question is, well, to what extent can any single international tribunal deal with the actual territorial dispute over Crimea or the dispute over alleged Russian intervention in eastern Ukraine? The answer to that question is simply that there isn't any international tribunal able to do that because there's no single tribunal that has jurisdiction over this dispute. So instead, we have this very interesting situation where we have a huge array of different courts, each with highly specialized jurisdiction, looking at a very particular legal claim that falls within this much broader dispute. So, for example, the International Court of Justice is currently dealing with a case brought by Ukraine against Russia in relation to Russian activities in Crimea and eastern Ukraine, but not over a territorial dispute, not over intervention as such in eastern Ukraine, but instead looking at Russian compliance in those two regions with two very specific treaties. The first is the Convention on the Elimination of Racial Discrimination. The second is the International Convention on the Suppression of the Financing of Terrorism. And that isn't because Ukraine thought, well, these are the two most important legal bases we have to challenge Russian action. It's because those are the only treaties between Ukraine and Russia that contain what we call a compromissory clause, a clause that says if a dispute arises concerning the interpretation or application of this treaty between any of the parties, that dispute can be submitted to the International Court of Justice. So that's just one of the cases. We then have a range of other interstate cases brought by Ukraine against Russia. So these include 5 pending claims before the European Court of Human Rights, a tribunal set up under Annex 7 of the UN Convention on the Law of the Sea. We also have lots of individual claims. So we have claims of individual Ukrainian investors within Crimea who, when Russia annexed Crimea, suddenly, in theory, became protected by an investment treaty that applies between Russia and Ukraine, which says, well, you have to protect the investors of the other state when they're in your territory. And if Crimea is now part of Russian territory, those Ukrainian investors who until then were just normal private domestic investors suddenly became subject to rights under the bilateral investment treaty. So these are all different claims, and they're, in a way, all effectively methods by which Ukraine and others could potentially try and nudge an international tribunal to say something about Crimea or eastern Ukraine. They're unlikely to go into a lot of detail on that. They're, generally speaking, likely to try and steer clear of too many controversial issues that they probably don't have jurisdiction over. But that's one sort of really interesting example of how we see international law being applied in practice. Some of that is IHL related, of course. So some of the claims before the European Court of Human Rights may well bring up questions of IHL. Because actually, if the Strasbourg Court decides, well, in fact, Russia is an occupying power in Crimea rather than the sovereign, then the law of occupation in theory applies there. And equally, if it views the separatist movements within eastern Ukraine as being sufficiently controlled by Russia, then suddenly what at first sight could be a non-international armed conflict in eastern Ukraine might suddenly become an international armed conflict. So, and then the potential for the Strasbourg Court to draw on IHL there is quite clear. So that's sort of one of the projects I'm looking at. The other is this very recent ongoing case before UK courts. So some of you may know that, I'm losing track of time, but I think 2 years ago, or maybe even 1 year ago, the UK's High Court, or the High Court of England and Wales, rejected a judicial review claim that sought to challenge the decision of the Secretary of State to continue permitting exports of arms to Saudi Arabia. So this was a judicial review challenge in light of the Saudi-led coalition's actions in Yemen that sought to challenge arms exports from the UK to Saudi Arabia on the basis that those arms exports may well be used to carry out serious violations of IHL. The assumption was that that had been sort of lost, but actually the Court of Appeal granted leave to appeal just earlier this year to the Campaign Against the Arms Trade, which is the interest group bringing this case. So interestingly, actually, in the UK, interest groups of this nature actually generally have quite a broad locus standi to bring these kinds of public interest challenges before UK courts. And so this is something that the Campaign Against the Arms Trade is currently doing. So that has just been granted leave earlier this summer to appeal. So that will then go to the Court of Appeal to hear that shortly. So that's another thing that I've been working on.
Maybe one last question that I would like to ask you, Professor Kolb, because so far we have discussed the influence that academia has over practice. I also want to dig a bit more into the state of the relationship between academia and practitioners today. And I wanted to refer to a blog post that maybe some of you have read earlier this year by Mike Schmidt, where he called for what he named an Athens and Sparta alliance between practitioners and academics on the law governing armed conflicts. And according to that blog post, we have on one side international lawyers and academics, which are called the modern-day Athens thinkers, and on the other side, the military legal practitioners, who are the modern-day Spartan warriors. And so the question raised by this blog post was on the state of the relationship between the thinkers and the warriors, the academics and the practitioners, and how we should be working more together to come up with solid contribution to the laws, things that are both well researched but also realistic and applicable in reality to real life situations. So I would like to turn to you, Professor Kolb, to say a few words on what you think is the state of the relationship between academia and practitioners today, and what you think should be done to improve that relationship.
Je pense que d'un côté, vous avez des relations relativement faciles, étroites, qui peuvent se nouer dans les contextes qui ont été mentionnés. Les académiques ont évidemment un impact relativement direct sur des groupes de recherche, ou le CICR par exemple, sur des tribunaux, sur des juges, parce qu'il y a une porosité relativement évidente entre la recherche dite scientifique, en tout cas la recherche juridique, et ceux qui doivent appliquer le droit à un certain niveau de densité, voire d'abstraction. En revanche, c'est plus difficile d'avoir une relation aussi directe avec la branche militaire de l'État. Je m'en suis rendu compte de manière plus capillaire lorsque j'ai commencé à porter la casquette de notre propre armée, c'est-à-dire que Je suis entré à l'armée suisse à l'âge de 39 ans. Je n'ai pas fait un service militaire normal. Je suis entré à l'armée pratiquement comme vétéran et comme volontaire. Et je suis toujours et encore dans la section droit des conflits armés de l'armée suisse et on essaye de faire de la promotion du DIH, ce qui n'est pas facile. Vous avez bien entendu, en Suisse, ce n'est pas facile. Parce que dans l'armée suisse, notre section est très favorable au DIH. D'autres sections, d'autres commandants le sont beaucoup moins. Je pense d'ailleurs qu'ils ne sont pas très favorables au droit en général et pas seulement au DIH. Sans devenir politiquement incorrect, le ministre est encore moins favorable au DIH, ce qui n'aide évidemment pas nécessairement. Mais le problème est plus structurel, au fond. Vous pouvez faire des contributions, et j'essaye de les faire. J'ai fait, il y a des années, j'ai écrit tout un cours pour des gradés moyens militaires d'armées étrangères, et on fait de la formation. Mais au fond, il me semble qu'il ne faille pas mettre ça sous la casquette de l'académique. C'est un académique, évidemment, puisque je suis un académique pur sucre. Je me suis égaré au CICR pendant 1 ou 2 années. Non pas, évidemment, que je ne l'ai pas apprécié, mais c'était un pur coup de chance. J'avais demandé à Georges Abissab, qui était mon directeur de thèse, de me trouver un travail pour l'été, parce que ça m'emmerdait profondément de ne devoir corriger que les coquilles de ma thèse. J'avais 800 pages, il fallait tout revoir, parce qu'évidemment, vous faites une première écriture, après, il faut s'y coller. Et donc, je me suis dit, si je dois faire ça pendant des mois sans rien faire d'autre, je vais être en apnée. Par conséquent, Abissab, est-ce que tu pourrais me trouver un travail d'été? Je suis arrivé au CICR. Mais il ne faut évidemment pas se tromper, je suis un académique à la base. Et je me suis rendu compte qu'évidemment, si vous avez des raisonnements académiques pour des juristes militaires, vous n'êtes pas franchement extrêmement utile pour eux. Il faut donc, même si c'est un académique, porter une autre casquette et développer une autre sensibilité dans ce domaine. Et cette sensibilité ne se développe qu'au fil de contacts assez réguliers que vous faites lorsque vous servez dans l'armée, par exemple, comme moi, quelques jours par année, et que je suis en contact avec des militaires de l'OTAN qui ont fait des opérations, puisqu'on les invite. Il est évident que les militaires suisses ne sont pas extrêmement utiles pour vous apprendre de l'opérationnel. En revanche, ceux qui viennent de l'étranger vous apprennent des choses très intéressantes. Il faut donc apprendre à porter une autre casquette et même à adapter le vocabulaire. Ceci étant dit, je ne crois pas que la tâche de l'académie soit de vulgariser le DIH ou de toujours nécessairement chercher de faire des apports, que ce soit pour des tribunaux ou que ce soit pour des militaires en particulier. On peut le faire, mais l'académie a aussi une autre tâche. La matière du DIH, c'est aussi une matière de réflexion à plus longue échéance. C'est une matière historique, c'est une matière philosophique, c'est une matière de réflexion. Et l'Académie est la seule à pouvoir mettre en contexte dans de longues plages temporelles les grandes lignes de fuite de la matière et l'approfondissement de questions juridiques jusque dans l'orfèvrerie. Ces livres en sont un très bon exemple. L'orfèvrerie, vous voyez, ça, vous n'écrivez pas une thèse de ce genre pour rester à la superficie des choses. Et ça, ce n'est pas quelque chose que peuvent faire ni des juristes militaires ni d'autres. Ce que je veux dire par là, c'est que chacun porte sa casquette et qu'il faut qu'il continue qu'il la porte. Nous n'avons pas à nous soucier d'être toujours pratiques. Nous devons nous soucier aussi de faire notre propre travail, un travail de réflexion de plus longue haleine qui peut après ressortir de manière inattendue, comme vous avez mentionné une thèse tout à l'heure, là où on ne s'attend peut-être pas. Et si on a envie, celui qui porte la casquette académique peut aussi s'engager dans d'autres contextes, comme je l'ai fait moi dans l'armée suisse, là aussi plutôt par hasard d'ailleurs.
Très bien. Merci beaucoup. I would like to now open the floor for any questions that may come from the audience tonight.
I'm Etienne Custer, advisor for relations with academia at the ICRC. So I'm really happy to be here tonight. It's really very interesting to have those discussions. I think it's rather a question to the whole panel because I see academia everywhere when I'm looking at that panel, despite the various affiliations. We had some answers about what drives academics to IHL from Julia, but I think I would be happy to hear more from the other panelists. What drives academics to IHL? What can drive academics to IHL? And also, I would be especially interested to know, in particularly regarding the ICRC, what can academic or what should academics expect from the International Committee of the Red Cross? That's something exploratory I would be very happy to hear about from your side. Thank you very much.
Julia? Or no?
Okay.
Yeah.
I do a lot of IHL, so I don't think I'm the right person to answer the first question you had, but maybe about what, as an academic, I'm looking for from the ICRC. You do already a lot. I mean, the casebook online, the review online, the commentary online, everything is online and freely accessible. You also convene some meetings, like the first Francophone network on IHL, and I think then we have to deep on that. Maybe in links with what you asked and what I said, I would like to insist on open access. I think that's very important in today's world in academia. I think that the ICRC does very well on that, because everything is accessible online with a footnote. All is accessible online, but only in English. So maybe other languages would be useful. But as academics, we also have to do more than what we currently do. I'm lucky, my PhD thesis is accessible freely online through the open archives of the University of Geneva. But for the source, I think that we need to produce more papers that are accessible freely online. And also that I think that the ICRC has maybe to promote academic research done by the source. I think that overwhelmingly it's English academic papers or work that is promoted, and from the north. So I think that what the source does in this respect is important to promote as well.
Thank you.
Really interesting question. The first, why researchers may be drawn to IHL, I ask myself that every day, I guess. I mean, for me, I think, at least, I mean, assuming that your interest is broadly in international law and why IHL in particular, my interest in IHL principally comes from the fact that it's really, you know, one of, if not the oldest branch, substantive branch of international law. And we see IHL featuring at a lot of very important milestones in the development of international law. So the first multilateral treaties were really adopted in the field of IHL. The 1899 and 1907 Hague Peace Conferences, which have really sort of formed the framework for subsequent international conferences, dealt in part with IHL, in large part with IHL. The expansion of public international law from being a purely really just interstate body of law to one that started regulating intrastate matters, which especially happened after the Second World War, materialized in large part in IHL as well. So Common Article 3 has to be sort of appreciated in that broader context of the emergence of international human rights law, the Convention Against Genocide, the prosecution of individuals for international crimes, many of these areas sort of losing that necessary background of interstate relations, which Common Article 3 obviously was. So for me, that's partly my interest, in large part my interest in IHL, because it's both a very old body of international law, but it's also reflective of a lot of changes over time in international law. What the ICRC can do for me, I mean, it's not often I get asked what someone can do for me. I really should have prepared something. Well, I think, I mean, this discussion about the relationship between academia and practice in IHL, to me, is interesting because I think IHL in particular, that dichotomy doesn't necessarily exist quite as much as it does in other areas. You know, we have ICRC legal advisors publishing academic articles. We have former military legal advisors becoming academics. We have academics that are also legal practitioners in cases involving questions of IHL. So that dichotomy isn't necessarily quite as, or I certainly wouldn't see it as quite as strict as perhaps I think it is in other areas maybe. But I do think, and I think that's in large part because there's such significant interaction. I think it's very useful and extremely valuable. I suppose one thing that I think would be very useful, I'm involved in a lot of sort of these groupings between academia and military and ICRC and other civil society organizations and NGOs, which are really valuable. But I do think that what would be helpful is a workshop like that where the ICRC, for example, can place 5 questions that are of particular importance to them on the table that can then be discussed, and academics in return can do the same. And I mean, we sort of have variations on this, but what would be valuable is if we had a forum, a sort of permanent established forum where that could be done. In fact, probably 5 questions each is too many, because I've been to ones where we've tried doing that, I guess. Maybe just 1 or 2 questions each, very practically speaking, would be ideal. I also think that there's one very valuable interaction should also involve judges, because it is domestic and international judges that are often applying both rules of IHL and other areas of international law. Historically, there was, I think, more interaction between judges and academics, at least in the UK, than maybe there is now. So that might be another thing. And if ICRC legal advisors could also be involved in that, I think that would be very useful.
Thank you. Professor Kolb.
Now you asked 2 questions. I will respond to the first in English, to the second in French. The first one is, you asked me more or less to do my biography. No, I did not come to IHL because I had a particular interest in that subject matter. I must say I was centered on the law of peace. At the time I was working at the Graduate Institute. And then I was engaged by the ICRC through Abissab, as I told you before, in order to prepare the materials for the Dictionnaire Salmon, the definitions of terms of international law. And then it happened that all the professors but one, who should have done the definitions for whom I had prepared the different materials, all these professors but one had no time to do the definitions, sometimes for dramatic reasons, because their wives deceased and things like these. And therefore I inherited all the work. I had prepared the work, and the ICRC asked me to do also the definitions, apart Schindler in Zurich, who did them himself for neutrality. And therefore I explored the whole subject matter of IHL, or law of armed conflict, from absolutely remote things, navicerts in the law of maritime warfare, up to military objectives. I had to look for all these terms, what was the exact meaning and the materials and the quotations. There is no better school to learn a subject matter than to have to do this, because you have a perusal of the whole material through time also, because you look to the different sources. And so I arrived to IHL, and then I was asked to teach it, and I worked here for 2 years in the legal division and so on. On the second, qu'est-ce que vous pourriez faire de plus pour les académiques? Écoutez, je vais vous répondre assez brutalement. De toute façon, je n'ai pas vraiment l'habitude de me cacher derrière mon doigt, d'autant plus que je suis massif. Il y a une chose où le CICR pourrait nous être beaucoup plus utile, mais j'avoue que vous n'avez pas beaucoup de marge de manœuvre et je sais que vous ne pourrez pas le faire. Il y a trop de matériel classifié au CICR, nous n'avons pas accès en tant que chercheurs parce que vous craignez que vous avez vos archives, évidemment, elles ne sont pas ouvertes pendant 50 ans. Vous avez beaucoup de peur du politiquement incorrect, vous avez des États que vous craignez et donc vous ne voulez pas les déranger et vous réfléchissez 50 fois si un document peut être donné. Pour des académiques, cela rend l'accès au matériel plus difficile. C'est là-dessus, je trouve que le CICR a une barrière avec nous. Nous sommes libres à l'université. Vous avez X contraintes. Mais je les comprends. Simplement, c'est là-dessus, si vous pouviez réfléchir une fois, d'être un peu plus souple peut-être. Quand j'avais fait ma recherche sur les prisonniers de guerre, je n'ai reçu aucune aide du CICR. Aucune. Refus net, total. Les rapports ne nous intéressaient pas du tout pour voir s'il y avait eu des violations. Pas du tout, les rapports des délégués du CICR, parce que les violations, ça ne fait pas du droit. Donc, ce n'est pas ça qui nous intéressait. Ce qui nous intéressait dans la recherche à l'époque, c'était de voir si certaines dispositions avaient donné lieu à des évolutions. C'est-à-dire si dans la pratique, on avait pu faire des propositions de faire des choses autrement. Mais malgré ça, évidemment, le refus a été total. Là-dessus, peut-être plus de souplesse, mais je ne sais pas dans quelle mesure cela est possible. Mais c'est à mon avis le plus grand stumbling block, pour parler de nouveau en anglais, que je vois dans la coopération entre l'académie. Vous êtes tenus et nous sommes libres.
Monsieur Bugnon, pour terminer cette discussion, je vous laisse la parole.
Merci beaucoup. Thank you. First of all, it was a fascinating debate. Thank you and congratulations again to the two laureates and also Professor Kolb for his contribution and Professor Christakis, who is not with us, but who also contributed to this evening by being a member of the jury. I would like to make three remarks. Professor Kolb defined himself as a theoretician and academic. I'm rather a practitioner, but nevertheless a strong believer in fundamental research, because at the end of the day, humanity progresses through fundamental research, whether in mathematics, whether in physics, whether in chemistry, medicine, or law, or history, which concerns us. To take just two examples, we would not have internet without the CERN, and we would not have the cellular phones, and tomorrow the self-driving car, etc., without spatial research. They did not search for this, but it's a byproduct. And humanity progresses through fundamental research, and it's something which also the ICRC has to keep in mind. For instance, history, which is totally neglected today, is also where we, as ICRC, can identify cases, examples, initiatives taken in the past, which can be used as an element in negotiation. I mentioned the Green Cross initiative of 1870, which led to all the action in First World War. Second remark, the ICRC relies on academic research, academic cooperation, very much in specific fields. I can mention here the customary law study, or the big, huge project on the new commentaries. These two projects achieved credibility through the decision to have widespread consultation and intense cooperation with the academic circles. So the customary law study, had it been carried out within the organization itself, would never carry the credibility which it received because of this wide network. Or, second instance, at a very difficult moment following the destruction of the Twin Towers in New York in September 2001, the 9/11 tragedy, there was a huge questioning, and I would say rejection, of international humanitarian law on the part of the United States government, United States media, etc., with, of course, very powerful means of influencing opinion, and initially very little reaction on the part of other countries. And what the ICRC did, we organized a series of consultations in different places in the world where we put together academics and government officials. And in a way, we used the determination, the faith of academics in international humanitarian law to remind governments on the importance which it would have. And I think it is largely through this cooperation, through this process, which we led to the next International Conference of the Red Cross, which eventually preserved and led us overcome this big, huge questioning of international humanitarian law. Now, my third remark concerns the ICRC today. The ICRC cannot rely on academics when it's convenient to it and forget about it the rest of the time. So I believe the organization should really have constance in its dialogue with academic circles and maintain the ties also when we are on rather clear waters, you know, good weather, and we don't need assistance. That's not the point. We have to maintain those contacts. Also, if we want to be able to rely on allies when we are facing a storm. Thank you.
Je peux ajouter une note très brève. Il y a une chose qui me vient encore à l'esprit. Il y a une excellente série, l'histoire des activités du CICR. Je pense savoir que cela a été arrêté. C'est avec très grand regret que je l'ai constaté. Il faudrait absolument continuer cette série qui était excellente, une source de première qualité.
Merci, Professor Kolb.
Thank you very much. Please join me in thanking our excellent panelists tonight and the two laureates again for their excellent contributions to IHL.